Welcome to the deep dive. I'm just so glad you're joining us today. Usually when we talk about the legal system or like workplace disputes, there's this expectation of just absolute precision.
Right. Yeah, it feels very binary. People want the law to be clean.
Exactly. We picture it almost like engineering, like the contract is breached, the dates are checked, some clerk stamps a document, and the judge just points to a specific clause and says, there it is, case closed.
Broken or not broken. But that's not always reality.
No, it's not, because then you step into the world of psychiatric injury, you step into the world of workplace trauma, and suddenly that precise legal machinery starts making some, well, really terrible noises.
Oh, absolutely. It is the absolute definition of muddy waters.
Right. We are looking at a diagnostic and legal landscape today that is incredibly murky. Because what happens when a workplace dispute turns so tragic that the primary witness, like the person actually at the center of the trauma, is no longer here to testify?
Yeah, that changes everything. The legal battle that follows a situation like that is immensely complex.
How does the legal system weigh a massive corporation's aggressive defense strategy against a deceased employee's written record? That is exactly what we are exploring today.
And we have some very detailed sources for this.
We do. We're looking at source material provided by AWDR. That stands for the Australian Workplace Discrimination Representatives. And they're a firm of non-lawyer workplace relations specialists.
Right.
They have supported over 16,000 clients across Australia over the last 30 years, handling everything from, unfair dismissals to deeply toxic work environments.
They've seen it all.
They really have. So the mission of this deep dive is to explore the profound boundaries of your workplace rights and where employer liability actually begins and ends. And we're doing this through a recent landmark case handled at the South Australian Employment Tribunal.
Okay, let's unpack this. We need to talk about the case of Emily Karate versus ALDI stores.
Yeah. And before we begin, I do want to emphasize that we are looking at a deeply sensitive, tragic case today. It involves a workplace suicide.
It's heavy. It is. So our goal here is to impartially examine the legal mechanics of what happened. We're going to look closely at the arguments from both sides, so the estate of the employee and the employer, and figure out what this ultimately means for employees and employers navigating the Fair Work Act.
Right, because the precedents set here are incredibly significant for how the law views trauma and corporate responsibility.
Exactly. And evidence, too.
Yeah. It is heavy material, but it's vital for you listening right now to understand how these mechanisms actually function. This really comes down to the power dynamics in the places where we spend the vast majority of our waking hours.
Oh, true.
To understand the legal fallout, we have to start with the inciting incident.
Right. So the timeline starts on July 14th, 2023. Emily Karati was working at an ALDI store in South Australia. She and her store manager intercepted a suspected shoplifter inside the store.
Okay.
And during this confrontation, things escalated rapidly. The suspect spat directly into Emily's mouth.
Ugh, stop for a second. Just think about the sheer visceral horror of that moment. That is not just a physical assault. It is a massive psychological violation.
Oh, completely.
Especially in a post-pandemic world where we are all hyper-aware of biological transmission,
The psychological toll was immediate and it was severe. The sources detail how this triggered profound, paralyzing anxiety for Emily regarding potential disease transmission.
I mean, how could it not?
Right. This was not a situation where she could just go to a doctor, get a shot, and move on. She faced an excruciating 3-month wait before medical experts could conclusively test her blood work and rule out any infectious diseases.
3 months?
Yes. For a quarter of a year, she was living with intense daily terror.
90 days of waking up every morning wondering if your life has been permanently altered by a random act of violence at your retail job. It's awful.
It is.
But the trauma of the assault is only the first piece of the puzzle here. How the company allegedly handled the aftermath is what turns this from a tragic event into an all-out legal battleground.
Yeah, this is where things get really complicated.
Because AWDR's documentation outlines some very jarring claims about ALDI management's immediate response. According to Emily and her mother, management did not contact the police.
Right.
They did not take any photographic evidence of the scene. And the store manager allegedly questioned Emily on what making a police report would even achieve.
Which is astounding. And the internal documentation process was even more problematic.
Yeah, tell me about that.
So when Emily was compiling her written statement about the assault for the company's internal records, the store manager allegedly instructed her, and this is a direct quote from the claims, to get it as close to mine as you can.
Wait. Let me make sure I'm hearing this right.
Yeah.
The manager told the victim of an assault to make her statement match theirs.
That's the allegation, yes.
If you're the employee in that moment, how does that not immediately signal a massive red flag about procedural fairness? I mean, it is like a director trying to force two actors to read the exact same script for a documentary.
Look, a great analogy.
You don't tell a witness to match someone else's story unless you are actively trying to control the narrative. How could any company consider that a standard investigative protocol?
Well, they shouldn't. That is
Right.
precisely the issue. When an employer attempts to synchronize statements like that, it ceases to be an investigation and starts looking like damage control.
Yeah, cover-up mode.
Exactly. And that moment fundamentally fractured the trust between Emily and her employer. And that fracture deepened significantly over the store's CCTV footage.
Right, the video. Emily wanted to see the recording of the assault, didn't she?
She did. She needed to process what happened to her. But she claimed Aldi's process for releasing that footage was protracted and, honestly, somewhat confusing.
Yeah, AWDR noted that Emily and her mother stated she was ruminating on the incident constantly.
Right.
The administrative delay in accessing the footage was cited as psychologically damaging. Emily even said she felt like she was being taunted by management.
That's a strong word. Taunted.
Well, look at the specific day mentioned in the sources. She came into the store on her day off. She came in specifically to view this tape because she had been told by management that she could.
Yeah.
But instead of showing her the tech, a colleague tells her that the manager had absolutely no intention of letting her see it.
This raises a critical point about the mechanics of trauma. Administrative delays, whether they are intentional stonewalling or just plain bureaucratic incompetence, they can severely exacerbate an acute psychological injury.
Because it strips away your control.
Exactly. The feeling of powerlessness is a massive driver of trauma, and the situation escalated rapidly from that point. On August 5, 2023, an area manager reported speaking to Emily on the phone. They described her sounding hysterical.
Oh, man.
And a few days later, around August 8, Emily was hospitalized following a severe nervous breakdown.
Okay, so she is hospitalized. She is dealing with a severe acute mental health crisis stemming directly from an assault that happened on the clock. And Aldi's response is to terminate her employment on October 6.
Yes. Tragically, less than 3 months after her termination on December 30, 2023, Emily Creedy died by workplace suicide.
It's just heartbreaking.
It really is. Prior to her death, she had already initiated legal action to dispute the rejection of her statutory workers' compensation claim. And after she passed, her mother, Rita Sargent, took over the administration of her estate.
Right, she stepped in to keep it going.
Yeah, she maintained the legal action and lodged a secondary claim for work-related death benefits.
Here's where it gets really interesting. Because Aldi does not just go to court to argue the facts of the case. They deploy a legal strategy designed to shut the entire case down before it ever reaches a courtroom.
They did. They filed an interlocutory application under Section 41 of the South Australian Employment Tribunal Act, 2014.
Okay, let's break that down for the listener. What exactly is an interlocutory application?
Sure. Think of it as a mini-trial before the main trial. It is a procedural request made to a judge to resolve a specific issue. In this case, a Section 41 application is a request for summary dismissal. It is a mechanism generally used when a party believes a claim has absolutely no legal merit whatsoever or, that a fair trial is structurally impossible to conduct.
So Aldi was basically asking the judge to throw the case in the trash before anyone even took the stand?
Exactly.
What was the actual basis for that request? Because Aldi's defense seems, well, almost paradoxical to me.
It's definitely a bold strategy. Aldi argued that Emily's death created what they called an incurable loss of evidence.
Incurable loss of evidence. Wow.
Objectively looking at their defense strategy, they claimed that because the applicant was deceased, she could not be cross-examined by their lawyers on the witness stand. Furthermore, she could not undergo an independent psychiatric examination by Aldi's chosen doctors.
Right.
Therefore, they argued, relying on her written statements over the live testimony of surviving store managers was fundamentally unfair and prejudicial to the company.
Hold on. I really want you, the listener, to absorb this logic. Aldi is essentially arguing that because the worker suffered such a severe outcome that she died, the company is suddenly immune to a trial.
That's the implication, yes.
They are using the tragic absence of the plaintiff as their ultimate legal shield. Just imagine the precedent that would set for anyone in the workforce.
It would be massive.
If a company's negligence or hostility pushes an employee to the ultimate edge, the company gets off scot-free precisely because the employee didn't survive to testify.
Yeah, that is the core tension of the case. And Aldi also went further to attack the reliability of the evidence she did leave behind.
How so?
They argued her extensive written statements were made under the oppression of mental illness, and they suggested potentially also serious alcohol abuse.
Wow, just attacking her character.
They pointed to what they labeled her delusional paranoia following the incident. Their position was that this underlying paranoia was the true cause of her death, not her employment at Aldi or the assault. They even claimed she had intentionally withheld details of this paranoia from her treating psychiatrist, creating further incurable prejudice against their defense.
And they actually called continuing the case an abusive process, didn't they?
They did. They framed their application to dismiss the case entirely as a proactive approach to save time and expense for the tribunal.
Save time. Why would a massive corporation try a maneuver like this? Do they actually think a judge is going to say, yes, the plaintiff is deceased, so you are off the hook?
Well, it is often a calculated war of attrition. Corporate legal teams know that grieving families have limited resources.
Right.
Filing complex interlocutory applications forces the other side to spend massive amounts of money and emotional energy just to keep the case alive. They hope the family will simply run out of funds or the will to fight and drop the case.
Just bleed them dry. But the South Australian Employment Tribunal, however, did not play along.
No, they didn't.
To really grasp what happened next, we need to clarify who the players are in this legal ecosystem. You have AWDR supporting the workers' estate. You have the tribunal, which acts as the court. Then you have the Return to Work Corporation of South Australia. What is their role?
The Return to Work Corporation is the statutory authority.
Yeah.
They essentially manage the state's work injury insurance scheme. They are the body that ultimately oversees the compensation funds.
Got it.
And they heavily opposed Aldi's move to dismiss the case. On April 17, 2025, they sent a very explicit formal warning letter to Aldi's solicitors.
A formal warning.
Yes. They advised Aldi that their attempt to dismiss the case completely lacked merit. And more importantly, they explicitly warned Aldi that persisting with this summary dismissal application would result in severe cost penalties.
And Aldi ignores that warning from the statutory authority. They push ahead anyway.
They did.
We get to August 2025 and the tribunal delivers its decision. They completely quash Aldi's claim of incurable prejudice. The tribunal pointed out something that feels like, honestly, basic common sense.
Yeah, they noted that Emily being absent was actually a much greater impediment to her own estate's case than it was to Aldi's defense.
Obviously. The prosecution lost their star witness.
What's fascinating here is how the justice system adapts to tragedy. The tribunal recognized that the unavailability of a key witness does not automatically render a trial inherently unfair.
Because she had already spoken to them, right?
Exactly. In Emily's case, she had provided a long and detailed record of interview prior to her passing. There was a solid evidentiary foundation to proceed.
Okay, that makes sense.
The tribunal stated plainly that the justice system would be rightly criticized if a worker's claim for an injury sustained during employment could be automatically defeated simply because they subsequently died.
That feels like a massive relief. But it leads to a bigger question. Where exactly does the tribunal draw the line between a company putting up a tough, legitimate legal defense and a company crossing the line into unreasonable legal bullying?
Well, the tribunal drew that line financially, and they drew it with a very heavy hand.
I love the sound of that.
After that decisive legal defeat in August, Aldi realized their position was entirely untenable. They abandoned their defense completely.
They just gave up.
In September 2025, they entered into consent orders to pay backdated weekly compensation payments up until the date of Emily's death. But the tribunal was not done.
Oh, good.
In March 2026, they handed down a massive penalty regarding the legal costs.
This goes back to that warning letter they ignored, doesn't it?
Precisely. Under Section 106(3)(a) of the Return to Work Act 2014, the tribunal has the power to penalize parties who act unreasonably.
Okay.
They found Aldi had acted unreasonably by pressing a groundless application after being explicitly warned by the Return to Work Corporation. So the tribunal hit Aldi with an adverse costs order.
Which means what, exactly?
It forced them to pay 85% of the applicant's legal costs on the higher court scale.
Okay, pause. Higher court scale. What does that actually translate to in the real world for a company?
Well, in a typical tribunal setting, Parties generally bear their own legal costs, or, costs are awarded on a much lower restricted scale to keep the system accessible.
Right, so everyday people can actually use it.
Exactly. The higher court scale represents premium litigation rates. It is the scale used in the Supreme Court.
Oh, wow.
It means ALDI was ordered to pay top-tier, exorbitant legal fees for the applicant's team. It is an absolute financial sledgehammer.
And well-deserved.
It is designed as a severe sanction to deter massive corporations from using their deep pockets to crush claims with frivolous procedural maneuvers.
Let's zoom out for a second. We have spent a lot of time on the extreme end of the legal spectrum with this case today.
We have, yeah.
For the listener who is just trying to understand their own standing in their workplace, what actually counts as a compensable psychiatric injury in Australia? Because look, everyone has bad days at work. We all experience stress. Where is the line?
That is a crucial distinction. To be recognized as a compensable psychiatric injury under the law, the condition must escalate significantly beyond ordinary workplace stress, frustration, or temporary sadness.
It can't just be my boss yelled at me and I'm bummed out.
No, it has to cross the clinical threshold into a diagnosed mental illness.
Yeah.
We are talking about conditions like major depressive disorder, generalized anxiety disorder, or post-traumatic stress disorder.
So a doctor has to be involved.
Yes, it must be clinically verified by a qualified medical professional.
Huh.
But here is the most critical element. The employment must be proven to be a significant contributing factor to the development of that injury.
Which is where ALDI tried to wiggle out of it. They tried to argue that her pre-existing quote-unquote delusional paranoia was the real cause of her death, completely separate from the spitting incident or the fact that management allegedly stonewalled her on the CCTV footage.
Yes, they tried to separate the events from her existing condition.
And that brings us to a foundational legal concept that everyone needs to know.
Yeah, if we connect this to the bigger picture of employment law, we have to talk about the eggshell skull principle.
The eggshell skull principle. I love that name.
It is a cornerstone of Australian personal injury and compensation law. The principle essentially dictates that an employer must take a worker as they find them.
I think about this concept like dropping a fragile glass on a concrete floor. You can't stand there and blame the glass for shattering just because it was made of thin material.
That is the perfect analogy.
The fact remains, you dropped it.
Right. The law recognizes that human beings are not perfectly resilient, identical machines. We all have histories. We all have varying stress tolerances.
Yeah, we're people.
Even if a worker has pre-existing vulnerabilities, perhaps an underlying anxiety disorder, a history of depression, or they are just naturally susceptible to stress, if workplace stressors worsen that condition, the employer is liable.
Which makes total sense.
Whether that stressor is severe bullying, chronic overwork, or a poorly managed traumatic incident like an assault, the employer cannot simply point to the employee's pre-existing fragility as a get-out-of-jail-free card.
So ALDI couldn't just point to her alleged paranoia and say, well, she was already fragile, so our hands are clean. The law says you hired her. She experienced a massive trauma on your watch. Your subsequent actions, or lack thereof, exacerbated her condition. You are responsible.
Yes, absolutely.
That is so incredibly empowering for you to hear as an employee. You do not have to be some invulnerable, titanium-plated robot to be protected under the law. Your human vulnerabilities do not cancel out your employer's legal responsibilities to keep you safe and to treat you fairly after an incident occurs.
And this case perfectly illustrates the immense power imbalance inherent in corporate disputes.
It really does.
You have an individual, or in this instance, a grieving mother, going up against a multinational retail giant with virtually unlimited legal resources. But the outcome proves that the legal framework does possess the necessary mechanisms to hold massive institutions accountable.
Even when they try to bend the rules.
The system pushed back, even when that institution tried to use complex procedural applications to suffocate the claim before it ever saw the light of day.
But when a massive corporation leverages that kind of aggressive legal loophole, an everyday employee doesn't stand a chance on their own, that power imbalance is exactly why specialists like AWDR exist.
Definitely.
Navigating the Fair Work system is not a DIY project. It is highly complex, and the timelines are aggressively short.
The time limits are extraordinarily strict. For instance, if you are dealing with an unfair dismissal, you only have a 21-day window from the date your dismissal takes effect to lodge your application with the Fair Work Commission.
Wow, 21 days.
If you miss that deadline, you will likely lose your right to challenge the dismissal entirely.
Think about that. If you just lost your job, your first thoughts are about paying rent, figuring out your groceries, and managing the pure emotional shock of being let go. 3 weeks goes by in an absolute flash.
It does. It's a very stressful time.
AWDR's documentation highlights that they provide 24/7 support across Australia precisely for this reason. They help everyday Australians find their voice in a system designed by lawyers, for lawyers.
And they operate on a very specific model.
Right. They operate on a basis of no ongoing costs, and in some cases, no win, no pay. That structure is vital when you are suddenly out of an income and facing down a corporate legal team. They are workplace relations specialists who understand the mechanics of these tribunal corridors.
But the Creedy case is a stark reminder that while the legal system can appear daunting and heavily weighted toward employers, the evidentiary burden does not disappear just because a company wishes it would.
Yeah, you can't just wave a wand and make it go away.
Detailed records, timelines, and expert representation are what ultimately defeated Aldi's attempt to dismiss the case. The truth, well documented, is highly resilient.
So what does this all mean? We started this deep dive talking about how the legal system isn't like an engineering schematic. It is not a clean binary snapshot. It is a messy, deeply human landscape.
It is indeed.
And that brings me to a final thought I want to leave you with today. The next time your workplace rolls out a shiny new policy on well-being, or they send out an email updating the incident reporting protocol, I want you to look closely at the mechanics of those systems.
It's a smart thing to evaluate.
Ask yourself, are these protocols genuinely designed to support and protect the employee experiencing the trauma? Or are they quietly, carefully designed to protect the company from the liability of that trauma? Because as we've seen today, the difference between those two things can literally be a matter of life and death.
A critical question for anyone participating in the modern workforce.
Thank you so much for joining us on this deep dive. Stay curious, stay informed, and we'll catch you next time.